It's time for all of us to be more intentional with our estate planning. Hi, this is financial planner Sean Mullaney. Let's discuss. So, I recently listened to an episode of the Earn and Invest podcast. I'll link to it in the description below. And Doc G had an interesting woman. Her name is Amy. She recently was widowed, and this was very unexpected. Her husband sadly passed in an accident. And she talked about the challenges she faced because her widow did not leave a will. And this became particularly troublesome because of a brokerage account this gentleman had that sadly he never named a beneficiary on. There was no beneficiary designation form on file. So you have no beneficiary designation form and you don't have a will. Well, guess what? You now have to look to the law of your home state. And they did in this case. And it turns out, a lot of people would just say, well, okay, he was married, at his death, so everything just goes to the wife. Not so fast. Under the home state law that this fellow's estate was subject to, that asset went largely to the wife, but not entirely, because he had no children, but he had living parents. So the living parents were entitled to a significant chunk of this particular asset, and this caused all sorts of problems. Lawyers got involved, it caused family strife, and the wife ultimately had to fork over a pretty significant piece of this asset, which is really sad because, nobody's death should cause even more grief, what Amy referred to as a secondary loss in her particular case. But these things can be avoided with just some estate planning, right? First of all, financial assets, retirement accounts, life insurance policies, got to make sure there's a beneficiary designation form on file. It's not a difficult exercise. It's always good to, on occasion, just audit that in your own life. Make sure that the relevant financial institution or employer has on file an up-to-date beneficiary designation form. A simple exercise that could save your loved ones a ton of legal fees in the future and strife. And then second, it's always good practice to have a will on file for a multitude of reasons. One of them is it can serve a gap-filling function. So say for whatever reason there was some problem with the beneficiary designation form, it didn't get filed properly. Hopefully it did, but if it didn't, the will can serve a great gap-filling function. And lastly, I know people sometimes can be skeptical of going to legal counsel and forking over a check to a lawyer for something that is not an urgent need. Well, what I'd say about that is it's better to pay lawyers when it's you implementing your own wishes when you're relatively healthy, sane, and not under pressure. What's a lot worse than that is your widowed spouse or your loved ones going to a lawyer shortly after the trauma of you having passed relatively unexpectedly, and now a lawyer has to come in and do a cleanup job, which can be a lot more expensive and a much more stressful exercise than you doing the planning with a lawyer up front when you're healthy. This is Sean Mullaney. I hope you enjoyed this video. If you did, please mash that like button and subscribe to my channel. I'll see you next time.